Apparently that's Mr. Haddad's case, I believe.
Judge.
And as soon as he gets on with us, I'll let him know that he's with us so that he can be interviewed if need. Oh, Mr. Haddad, good morning.
Hey, I didn't realize he was in the county. I guess I can call the number and talk to him on the phone if possible.
Okay, Coney, can you provide Mr. Eppinger to Mr. Haddad via phone for us, please? The number's on the screen, Mr. Haddad, if you need it. Okay, somebody will be with you. Thank you, Mr. Eppinger. We'll be with you. Good morning, sir.
Thank you.
So is there no one in courtroom 2 there that we can take right now? If not, we'll just be in recess.
Judge, I think we have 3 or 4 that are ready to go.
Okay, well, the court's ready whenever you all are, I believe.
Start with position 13, Davidson, negotiate.
Okay. Good morning, Mr. Davidson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Is that a yes? Okay, okay, thank you, Mr. Davidson. You can put your hand down. Thank you, sir. Good morning, Ms. Harrison.
Good morning, Your Honor. How are you?
Doing well, thank you.
The state's recommendation for Mr. Davidson, Your Honor, is in the charge of criminal trespass and damage to property is 12 months probation, served 60 days, Credit for time served 14 days. The defendant has been incarcerated since June 18th. The balance will be probated. We're asking for 8 weeks of anger management, 40 hours of community service, a stay away from H&R Mart located at 980 Hollywood Road in Atlanta, Georgia. And we'd ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, Your Honor.
Mr. White, you all are muted there.
Sorry about that, Judge. We stipulate for the purpose of the plea, we just ask that probation terminate upon completion of all of his requirements.
Mr. Davidson, it's my understanding that in case 25 CR 003412C, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right? You don't want a jury trial, do you?
No, sir.
And you know that you can get a jury trial if you wanted one, but because you're pleading guilty, you're giving up that right to a jury trial. Do you understand that?
Yes.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Davidson. As soon as you complete all the terms, I'll have the probation terminate. So the sooner you get it done, the sooner you're not going to be on probation, okay?
Thank you, Your Honor.
Good luck to you, sir.
Do position. Organized for that.
Judge, we can do position 27 next, Marcus Ross. That'll be a non-negotiated plea.
Okay. And I take it the jail time is what's not negotiated?
That is correct, Your Honor.
Good morning, Ms. Washington. Are you with me?
Yes, I'm here, Your Honor.
Yes, good morning. Can I get Mr. Ross's history, please?
That's Marcus Ross.
Yes, position number 27.
Okay, I'm sorry, my computer is freezing. Give me one moment. Your Honor, can you come right back to me? My computer is frozen.
Okay. Ms. Harrison, do you have the history?
Your Honor, I'm pulling it up. No, I did make a note that he had a PI case in 2016 and a peeping Tom in 1991. He does have a lengthy criminal history. Give me just 1 second. I got all the cases this morning. So I'll pull it right up for you. Okay.
I have it, Your Honor.
Okay.
There are 74 arrest cycles in Georgia. The last arrest appeared to be from March of this year for felony theft by shoplifting. That case appeared to be dismissed. There was a 2024 burglary out of Fulton County. There was an FTA from 2021. There was also a burglary in 2018 out of Fulton County. There was a 2017 misdemeanor conviction for criminal trespass. There were 3 separate ones for criminal trespass in 2017. There's also a 2006 felony conviction for a burglary. A theft by taking felony conviction from 2005. Another burglary also from 2005. Arrest and convictions for theft by taking in 2004. A felony conviction in 2003 for possession of a controlled substance. Also in 2001, there was a felony conviction for entering auto and theft by receiving stolen property.
Okay, thank you. Thank you, Ms. Washington. I appreciate it.
You're welcome.
Yes, Ms. Harrison.
Yes, Your Honor. This incident occurred on June 14th. The place of the occurrence was Washington Road, the actual parking lot of 3887 Washington Road in East Point, Georgia. Officers were advised and called to the scene due to a female driving by southbound on Washington Road. She informed officers on the call that she observed the defendant on the side of the road waving his penis. And officers, she pointed him out, and officers were able to go to the location and find the defendant. He was sitting across from the victim at the time, Miss Malia Gaither. And officers asked her what occurred, and she informed officers that she was sitting at the bus stop across from the defendant, and she didn't do anything, and he was waving his penis in the air. And she believed he did it on purpose and was making noise to her to get her attention so she would look at him. And he was holding it in his hand. And like I said, Your Honor, the state he did have prior similar cases like this, the 2016 PI case. And as such, the state's recommendation, Your Honor, is, I'm sorry, one second, I lost my place. Where did it go? The state's recommendation in this case is 12 months served 90 days, 15 days credit for time served. The defendant has been incarcerated since June 17th, balance probated. We're asking for SDET, 40 hours of community service, no further contact with Malia Gaither. And the defendant also has another case. It is SG 73124124. For that case, the state's recommendation is a 12-month probation concurrent with this case. Stay away from Chevron, located at 4485 Washington Road in East Point, Georgia. And that'll be all for the state. We ask that the defendant stipulate to venue, purposes, and ID.
What is the charge for the add-on case?
It is a criminal trespass.
Yes, Your Honor, and the case number is 25 CR 003645. F is in Frank, criminal trespass.
Thank you, Ms. Young.
You're
Thank
welcome.
you.
Whenever you're ready, Mr. Masajian.
Thank you, Your Honor. As Your Honor alluded to before, the only real quibble we have with the state's offer is that we asked for Mr. Ross to be given 30 days to serve and 15 days credit for time served so that he'll be released as long as there's nothing else holding him within the next 24 hours. We understand he has a significant amount of cycles, but these are pretty much all related to, by what I could hear, crimes of poverty. As far as PI cases, the state mentioned one case from 9 years ago, another one from over 30 years ago. Your Honor, we just feel that the jail time is excessive, given that Mr. Ross has already done 15 days at this point. So we would just ask, Your Honor, that the jail time be reduced and all other conditions remain the same.
Okay, I'll need some background on Mr. Ross. I'll need to know if he needs services from a social worker. Does he have a place to stay? Things of that nature. Does he have a job? Is it going to be difficult for him to accomplish what the state is asking? I don't want to set him up for failure.
Yes, Judge. Mr. Ross does have family in the area that he was previously staying with his niece. He also has his father who's local here in the city. He receives a Social Security check every month for his income. So he does have a place to stay. He does have not employment, but he has income. Your Honor, we believe that he will be able to land on his feet once he's released.
Okay, I'm not sure if keeping him in custody, it would be the solution, but I do think that there needs to be, along with the SDET, a mental health evaluation. So I would order a mental health evaluation along with the SDET. You're telling me that he does have a place to go, and that he does have some type of income, so I'm going to keep him on probation for the entire 12 months. But I would require him to do MHET as well. Do you need to discuss that with him?
Yes, Your Honor, just for 1 minute. Thank you, Judge. Thank you, Judge. Mr. Ross is going to plead guilty under those conditions.
Okay. And Ms. Harrison, that Washington Road address, was there a specific business that he was in front of, or was it the roadside? Where was that?
Give me just 1 second, Your Honor. Yeah, it's the Chevron located at 4485 Washington Road. So Chevron service station.
So for both cases, it's the Chevron, the same Chevron?
The public indecency was at a bus stop in a parking lot. So I'm guessing they're all pretty close.
If there's a location that you want him to stay away from for the PI, I'm happy to order that.
Okay, the location would be the parking lot at 3887 Washington Road.
3887, okay.
Okay, thank you.
If nothing further, Mr. Ross, it's my understanding that in case 25 CR 003402Y, you wish to plead guilty to public indecency. And in case 25 CR 003645F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. Yes, sir. Yes, sir. I'm supposed to ask. I don't want to answer. Yes, sir. I'm gonna ask, sir. So I be on probation. I get on probation.
Okay, yes, Mr. Ross, you will be on probation.
Sometimes you get on probation. 12 months.
Yeah. Yes, sir. If you go through with the plea, part of the plea arrangement is that you're going to be on probation for 12 months, okay?
Okay, yes, sir. Yes, sir. Yes, sir.
Okay. So do you wish to plead guilty to this public indecency and criminal trespass to those charges?
Yes, sir. Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning, Mr. Ross?
No, sir. No, sir.
You've been represented by Mr. Massageddin there. Are you happy with what he's done for you?
Yes, sir. Yes, sir. Yes, sir. So I'll do that tonight.
He'll let you know when you'll be getting out, okay? So, you understand?
I do that tonight.
You understand? Okay, you'll be getting that, if you don't have anything holding you, Mr. Ross, you'll be getting out as soon as the jail can process you out, okay?
Oh, yeah. Hey, net,
Okay, well, if that's, okay, if that's the case, Mr. Ross, then you'll be getting out as soon as they can process you out, okay? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty, you're giving up that right?
Yes, sir. Yes, sir.
Has anyone forced you to plead guilty?
No, sir. No, sir. No, sir.
Okay. I'll accept your plea, Mr. Ross. For the PI, the court sentence is going to be 12 months to serve 30 days, credit for time served 15 days, the balance probated, an SDET and MHET, 40 hours of community service, and no further contact with Ms. Gaitier. for the criminal trespass, will be 12 months concurrent, and to stay away from the Chevron at 4485 Washington Road. Also for the PI, you to stay away from that bus stop that's on Washington Road as well. So you can't go back to that Chevron, and you can't go back to that bus stop. You understand me, Mr. Ross?
Yes, sir.
If you need to talk to him, Mr. Misogyny, I can't hear him because they have him muted, so if you need to answer a question for him, or I'm happy to speak with him if need be.
Thank you.
I do, sir. Thank you.
Okay, all right, and so, Mr. Ross, I understand your situation. While you're on probation, I'm gonna waive those fees, okay? So all you have to worry about is reporting, make sure that you report, and make sure that you get this, the terms of the probation done, okay?
Yes, sir. Thank you, sir.
All right, good luck to you, Mr. Ross.
Thank you.
Judge, can I make a quick announcement, Judge?
Yes, of course, Mr. Val.
We can get the Oconee County out of the way. It's gonna be a not guilty judge on Mr. Eppinger. I think it's 15 or 16.
Okay, yes, it's position number 15, Mr. Eppinger. Mr. Eppinger, your case will be returned to the division judge, and you'll get notification of your next hearing date, sir.
Thank you, Judge.
All right, good luck to you, sir.
Are we accused, Your Honor?
41 next, Williams.
Okay. Good morning, Mr. Williams. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can place your hand down. Yes, Ms. Harrison.
Yes, Your Honor. The state's recommendation is for count 1, battery family violence, 12 months served 36 days, credit for time served 18 days. The defendant has been incarcerated since June 14th. The balance probated. We're asking for completion of FVIP, a $300 fine, no further contact with Carlos Ragland, a stay away from 1655 West Lake Court, no firearms. Count 2, battery family violence will merge with count 1, and count 3, simple battery family violence will merge with count 1 as well. The state asks that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. Your Honor, we have not made contact with the victim, Mr. Ragland, today, but we would like to sound for him just in case he's joined us in court, and that'll be all for the state.
Mr. Ragland is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Mr. Misogyny?
Thank you, Your Honor. Mr. Williams, we would like to request that for him, all other conditions of the state's offer can remain the same, but we would ask that as far as between Mr. Williams and Mr. Ragland, that they do be allowed to have contact, just that it be no violent contact. Mr. Ragland is a blood-related cousin to Mr. Williams, and Mr. Ragland was in fact staying with Mr. Williams. But the apartment there belongs to Mr. Williams. Mr. Ragland no longer resides there. Mr. Williams helps to take care of Mr. Ragland. He suffers from a form of epilepsy and seizures, which is why we believe that he's presently in the hospital, which is why the state hasn't been able to get in contact with him, why he's not here today on the call presently. But we would just ask that Mr. Williams be allowed to return to 1655 Westlake Court. That is his place of residence. It is a apartment for low-income individuals. So Mr. Williams does have a voucher to stay there that he's at risk of losing if he's not released or returned soon. And that if required, Mr. Ragland will not stay there, but the apartment does belong to Mr. Williams. But we would also ask that there be no violent contact between Mr. Ragland and Mr. Williams.
Harrison?
Your Honor, I have reviewed the facts of this case. The state is not opposed to no further violent.
Very good, thank you. If nothing further, Mr. Williams, it's my understanding that in case 25 CR 003350G, you wish to plead guilty to battery family violence, is that correct?
That is correct.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Very much so.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, I do.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated with the change to no further violent contact with Mr. Ragland. And you can continue to reside at the Westlake Court residence. When you complete the terms of the probation, Mr. Williams, I'll have it go to a non-reporting status. So when you get everything done, you won't be on reporting probation and won't have to pay those fees, okay?
Okay, thank you.
You're welcome. Good luck to you, sir.
Okay. Your Honor, positions 8 through 10, coffee.
And this is going to be a bond hearing, is that right, Mr. White?
That's correct, Judge.
All right.
Come on, y'all.
Good morning, Mr. Coffey. Ms. Washington, may I get the history, please?
Yes, Your Honor, 37 arrest cycles. Prior to this case, there was an FTA from 2025. There was a NOLO plea in 2025, March, for theft by shoplifting. There is an open pre-indicted case from 2024 for 2 counts of burglary, criminal damage to property second, and willful obstruction. There's a 2024 misdemeanor conviction for criminal trespass, willful obstruction, and simple assault. A separate 2024 misdemeanor conviction for criminal trespass, disorderly conduct, simple assault, and theft by taking. A 2023 felony conviction for terroristic threat and interference with government property. 23 misdemeanor conviction for willful obstruction and disorderly conduct. A 2020 felony conviction for terroristic threat and willful obstruction. A 2017 felony conviction for aggravated assault. A separate 27 felony conviction for terroristic threat, willful obstruction, criminal damage to property, DUI, and aggravated assault. In 2014, there was a misdemeanor conviction for theft by shoplifting. And also in 2017, there was an arrest for theft by shoplifting, but that case was dismissed. Nothing further.
Thank you. And Ms. Harris, if you can remind me, why was this case reset? I believe it was reset from last week. Is that not right?
I'm actually not sure, Your Honor. I'm sorry, you gotta bear with me. I
Okay.
just got this half of the calendar this morning.
Okay, yeah, you're fine, Ms. Harrison. Let's see. First, can you tell me what the current bonds are?
Yes, for the first case, the position 8, position 8 was the theft by shoplifting and willful obstruction. For that case, I have a bond set at $1,000 surety bond set by Judge Law in November. For position 9, the criminal trespass case, I have a bond set at $5K surety by Judge Law. And I was actually in the midst of the third one. Give me just one second. And I'll get you that amount.
What?
For position 10, the bond was a $50,000, I'm sorry, not $50,000, a $50 cash bond. And that was issued by Judge Law on June 7th. Okay.
All right,
And
thank you.
You're welcome.
1 second, please, Your Honor.
And Your Honor, the cases reset from last week because the state asked for extra time.
Okay, thank you,
That's
Ms.
why
Young.
it was reset.
Thank you.
Thank you, Ms. Young.
Judge, okay, I'm ready. So,
Hold on, Mr. White. Ms. Harrison's not completed with her presentation yet.
oh, I'm sorry.
Okay. Okay, we ready, Your Honor? Okay.
Yes.
Okay, for the first case, position 8, the state's recommendation is count 1, 12 months probation, served 90 days, credit for time served 26 days. The defendant was incarcerated since June 6th with the balance probated, an anti-theft course, 40 hours of community service, a $500 fine, a stay away from the BP gas station located at 464 Windsor Street Southwest.
Ms.
And
Harrison, I'm sorry to interrupt you, but as this is just a bond hearing, I just need to know the
oh, I'm so
facts.
sorry. I don't know why I was thinking non-negotiated. Okay. Yes. On 11/1/2024, officers were dispatched to the BP gas station at 646 Windsor Street for a call of property damage. When they arrived, the defendant was in handcuffs and he was being detained by security guards. When officers asked to have his handcuffs removed, he was very aggressive and intoxicated. They asked for his name. He wouldn't give it to him, and he continued to cuss officers out. They switched the handcuffs with security and put him in the back of the car, and he continuously kicked the patrol car door as well as spit across the car multiple times. The second incident for position 9, the criminal trespass and damage to property. This incident occurred on May 17th. Officers were dispatched to 884 Rose Circle Southwest in response to individuals inside a residence unlawfully. When they arrived on scene, they were met by Mr. Hamilton, who called 911. He works for Sovereign Realty and Management, and he stated that he tried to open the front door, and the defendant answered the door, trying to persuade him to enter. He went back to his car and waited for officers to arrive on scene. And when officers arrived on the scene, they observed the front door open and they saw people roaming about inside the residence. They approached the door, announced, and asked for everybody to come out with their hands up. And they spoke to 2 black males walking up the street from around the house that matched the description that Mr. Hamilton had given the officers of the people that were inside the house. One of the people identified himself as Mr. Coffee, was told to get down on the ground, and he did not comply with officers. Officers had to use a taser to gain compliance from him, and they were subsequently able to place him under arrest. They noticed that the door was in working condition, and but they did see damages to the door on the house. The third incident, Your Honor, occurred. Give me just 1 second to get back to that screen. So theft by shoplifting occurred on April 28th. And officers responded to a call. Sorry, honestly, it's freezing. Okay. Officers responded to a call at 507 Joseph E. Lowry Boulevard, which is the Chevron gas station, regarding a shoplifting. They met with the store clerk, who advised them that the defendant walked into the store around 7 a.m. and proceeded to go over to the first cooler. They asked him, he had a red bag, which he used to place 2 cans of Rita beers valued at about $9 into the bag, and proceeded to walk out the front door. But he threw down his EBT card, and the store informed him that they don't take EBT, and he never subsequently paid for the beers, and officers were able to corroborate that incident with surveillance video. The state's recommendation, Your Honor, in each case, the first case, position 8, so It's theft by shoplifting and willful obstruction. The state's recommendation here is $1,000 on each charge or surety bond. A stay away from the BP gas station located at 464 Windsor Street. For the second case,
Ms. Harrison, are you there?
She walked away, Your Honor. I don't know if something happened to her audio.
Okay, thank you, Ms. Young. Ms. Lewis, are you with me?
Yes, Judge, I'm here. I'm sorry.
Can you- Would you give me a call? Would you give me a call, please?
Yes, I can.
Thank you. Court will be at a brief recess.
Good morning, Judge Morrow.
Yes, good morning, Ms. Falk.
I heard that we lost Miss Harrison, so let me step in for a moment for her and handle the rest of these cases.
Okay, thank you, Ms. Falk. I appreciate it. We are on positions number, Mr. Coffey, positions number 8, 9, and 10. He was reset from last week. I think that you might remember. We've gotten all the way to the recommendation. It's a bond hearing. I've heard everything from Ms. Harrison except for position number 10. He has a $50 cash bond that was set by Judge Lowe, and I need to know what the state's position on that is.
Yes, Your Honor. The state's position on that case is that bond should remain as set. Judge Law is usually very good about putting some notes in the bond order that states the reason the bond should remain was set the way it was. So let me just go to her bond order. It looks like she said it was the 38th arrest by this defendant. He has multiple cases open in Superior Court and has a judicial hold, as well as she cited to 25, excuse me, CR 002800F, which is, let's see. Trying to see if that was another case on our calendar.
That's position number 9, I believe.
9. Okay, so she cited to that as well for the reason that she did not agree with a bond less than $50 in cash. It looks like the defendant has quite a few theft by shoplifting cases open, as well as the criminal trespass and damage to property case, which is why the bond was set as it is, as well as she stated a judicial hold. It looks like that judicial hold is from a from a willful obstruction, terroristic threats, interference with government property case under 25 SC 002616. So he has quite a number of open cases as well as that hold, which is why, and he does have an open burglary, unindicted, burglary, criminal damage to property, willful obstruction, burglary, second degree, 24 DA 12347. That occurred December 14th of 2024, and a different open criminal damage to property. Well, nope, that looks like it was closed. That was a September criminal damage, criminal trespass, willful obstruction, and burglary in the second degree that was subsequently closed. He also has an open 25 SC 000470 criminal damage to property in the second degree and criminal trespass case that is also open. So, you know, it's talking a lot just to say he has a lot of open cases, Your Honor.
Okay, thank you, Ms. Falk. Yes, Mr. White.
Thanks. Yes, Judge, the War and Peace. So we got, we're just asking for a $2,000 total bond, surety bond on the 3 cases. The FTA that pretrial mentioned earlier was one of these cases where the notice went to the wrong address. He's had the same mailing address for his whole life. And this one went to, it was one number off apparently. Should have been 880, went to 800. He has a disability hearing coming up this week that we would like him to be able to get to. He has been in touch with our social workers. They've lined up a whole series of things for him to do when he gets out, including going to 10 Park Place. And there's some help there that they've already put in place for him, I think. So we're just asking, his mother can bond him out if it's $2,000 surety bond or less. So that's what we're asking for, Judge. He has been in jail also 28 days at this point since those bonds were set. And obviously he has not been able to make it.
Okay, the bonds for positions 8 and 10, I'm going to leave as set. The bond for position number 9, the criminal trespass and damage to property, I will lower that to $1,000 good bond with all the conditions that were in the initial bond. So if you'll prepare that, Mr. White, we'll get it signed. Good luck to you, Mr. Coffey.
Right, so that's going to be, what is that? Position 8.
I'm sorry, y'all.
What is the number?
Whatever the bond is, and I was told it was $1,000 good bond, so I take it that's $500 per charge. That's what I was told previously. So
I just want to make sure, Judge. So I've got 2,000 surety and a 50 cash. Is that correct?
what I was told was position 8 was $1,000 good bond, position 9 was a $5,000 good bond, and position 10 was a $50 cash bond. I am lowering position 9 to $1,000 good bond.
That's what I do, Judge. I just want to make sure that we're
Okay. All right. So, Ms. Lewis.
Yes, I got a question, Judge. He's only being held for 2 charges. His total bond is $1,050. He's not being held for the other 2. Only two charges on his booking screen right now is theft by shoplifting, misdemeanor of the offense of April the 28th of 2025 of a $50 cash bond, and the rearrest that they surrendered him on the pretrial bond of $1,000 for the criminal trespass damaged property that happened on May the 17th of 2025. So his total bond is only $1,050 to get out. I just want to clarify, just letting y'all know.
So just to be clear, it's $1,000 surety plus the 50 cash is what you had?
That is correct.
Mm-hmm.
Okay.
He's only in there for 2 charges. He's not in for all the rest of the charges that y'all are indicating on his count. He's only booked in for the two cases.
Right. So just to let the court know, the bond that you modified and reduced to $1,000 surety, position 9, that was already $1,000 surety. It was a $5,000 signature bond through pretrial services. They then surrendered that bond and turned it into a $1,000 surety bond.
That's correct.
So,
Judge
Your Honor,
Carvalho,
essentially, the bond is still remaining as it was originally set once his bond was surrendered. Is that tracking with everyone?
It's tracking with me. It's correct.
I know with you, Miss Lewis.
It's correct. That's why that's why I didn't want it when y'all was saying 2,000. I was like, what? Y'all making the bond higher than what it is.
Just so we're clear, what paperwork needs to be done, Ms. Lewis? Do we need to, does any additional paperwork need to be done, or are we good?
If you're gonna keep the bond as it is, and that he's in jail on, then there's no paperwork because he just got to post a $1,050 bond unless y'all, it's the cash bond and $1,000 surety.
Okay. So we went.
I'm just saying y'all doing extra paperwork for nothing. That's all I'm
We went
saying.
to that 25 minutes of, all right. Good luck to you, Mr. Coffey.
And my apologies for the confusion, Your Honor.
No worries. Are we good, Mr. White?
Yes.
Okay,
Yes, Your Honor.
all right. Where to next?
Good morning, Judge Morrow. Hope you're doing well. I have
Hi.
position number 32, Ms. Janice Smith.
Good morning, Francois. I am. I hope you are as well.
Thank you.
This is going to be a negotiated plea, is that right?
It is, Judge.
32,
Position 32, yes, Judge.
okay. And negotiated plea, is that right?
Yes, Judge.
Good morning, Ms. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Will you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Speak up for me or scooch up for me.
Yes, sir.
All right, thank you, Ms. Smith. You can put your hand down. Thank you. Yes, Ms. Harrison.
Yes, Your Honor. For count 1, loitering and prowling, the state's recommendation is 12 months, probation served 34 days, credit for time served 17 days. The defendant has been incarcerated since June 15th, balance probated, stay away from 1263 Gus Thornhill Drive, completion of ADET, and for count 2, possession of drug-related objects, 12 months probation concurrent with count 1. We ask that the defendant stipulates venue, ID, and facts of the case for purposes of the plea. That'll be all for the state, Your Honor.
Honor, we stipulate, due to the nature of the charges, I would ask the court to consider non-reporting upon completion of the ADET, Judge, and of course, stay away stays into effect, Judge.
Okay. Ms. Smith, it's my understanding that in case 25 CR 003361G, you wish to plead guilty to loitering and prowling and possession and use of drug-related objects. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? Scooch up again for me.
No, sir.
You've been represented by counsel. Are you satisfied with his representation? Say it again.
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yes,
Was
sir.
that a yes? Has
Yeah.
anyone forced you to plead guilty?
No, sir.
All right, I'll accept the plea as negotiated, Ms. Smith. When you complete the terms, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees, okay? All right, good luck to you, ma'am.
Thank you, Judge.
Welcome.
Good afternoon. Yeah.
Position 38, Mr. Upkins.
Also a negotiated plea.
That is correct, Judge.
Good morning, Mr. Upkins. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? All right, thank you, sir. You can place your hand down. Ms. Harrison?
Yes, Your Honor. The defendant has a FTA, he has a prior underlying charge. The case number is 23CR 007654J, which is a battery charge. Our offer today, Your Honor, is a 12 months served, 38 days, credit for time served, 19 days. The defendant was incarcerated December 1st through 3rd of 2023 and incarcerated again on the FTA on June 16th. The balance will be probated. Completion of a FVIP, 40 hours of community service, no further violent contact with Philip Harshaw, and a stay away from 646 Boulevard Drive Northeast, and no firearms. And then the FTA, Your Honor, will be no prost on the plea to the underlying charge. We ask that the defendant stipulate to venue ID and facts of the case for purposes of the plea.
And defense so stipulates for the purposes of the plea this morning, that is our understanding of what the state's offer was. Mr. Upkins will plead guilty this morning.
Hey, Mr. Upkins, it's my understanding that in case 23CR 007654J, you wish to plead guilty to battery, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes.
Has anyone forced or coerced you to plead guilty? I'm sorry, say it again for me. I'll accept the plea as negotiated, Mr. Upkins. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, sir.
Position 24, Mr. McInnes.
And this is going to be a bond hearing.
Yes, Your Honor, we would like to have a bond hearing for Mr. McInnes here.
Okay, Ms. Washington, may I get position 24, Mr. McInnes's history, please?
Yes, Your Honor. There are 20 arrest cycles out of Florida and 16 arrest cycles out of Georgia. There's a 2016 felony conviction for tampering, possession of drugs, and possession of misdemeanor marijuana, an FTA in 2014. In 2011, there was a misdemeanor conviction out of Florida for criminal mischief above $200. The last arrest appeared to be from December of last year for possession of a controlled substance, which is a pre-indicted case in Fulton County. There's a 2025 felony conviction for 2 counts of theft by taking, card theft, and dumping a hazardous waste, and the defendant is currently on probation for that case. Also, there are 2 FTAs from 2024, a 2024 possession of drug-related objects, also a 2024 possession of controlled substance, and a 2024 criminal damage to property in the first. Nothing further.
Thank you. What are the current bonds, Ms. Harrison?
The current bond is a $500 good bond, Your Honor, with the condition to stay away from 365 Lindenberg Drive and no further contact with Tierra Ayers, the victim in this case.
And the battery, I see that there's an add-on.
Oh, sorry, one second.
Are there any?
Yes, give me just 1 second.
Is he being held on both of these, Mr. Masajidan? Do you know?
Your Honor, I believe just on the battery case. Or I'm sorry, Your Honor, just on the theft by taking. He also has a VOP hold.
So he's not being held on the battery charges? Is that what you're telling me?
Not to my knowledge, Judge. Correct.
Yes, correct. I actually can't see the bond for the battery case, Your Honor.
Okay, well, that's fine. So he's only asking for a reduction of the $500 good bond. Is that what you're telling me, Mr. Masajuddin?
Yes, Judge, we're asking for a signature bond as to this theft by taking charge for Mr. McKinnis. He does have a good address here in Atlanta where he lives with his mother. He's a job waiting for him when he gets out, which, as we already stated to the court, will not be immediately following whether Your Honor gives him a signature bond now or not. He does have other matters holding him in custody, but he does have a job waiting for him. His mother is the manager at Burger King on Cascade Road, so he will have that employment waiting for him when he's released. He's also a high school graduate and a father to two young girls, both that he has full custody of. They're 10 and 11 years old that he helps take care of along with his mother, the children's grandmother. So we would just be asking, Your Honor, for as to position 24, the theft by taking 25 CR case that Mr. McKinnis receive a signature bond.
Ms. Harrison?
Yes, Your Honor. I'll get into the facts of the case. This incident occurred on June 17th at 6:35 Lindenberg Drive. Officers responded to Texaco gas station in reference to a larceny call, and they made contact with the victim, Ms. Tiara Ayers, who stated that her iPhone 15 was stolen from the gas station. They reviewed surveillance footage and saw a black male that officers recognized as the defendant on video taking the phone off the countertop and placing it into his left pocket. They did locate him at the back of the gas station asleep and conducted a pat-down search and found the shape of an iPhone was in his left pocket. They removed the iPhone and it matched the description of the victim's iPhone. The police were able to return it to the victim at the scene. Your Honor, the state's position is we would like to maintain the $500 surety bond to stay away from the 635 Lindenberg address and the no contact with the victim.
Okay, so Mr. Masajuddin, it will be a $5,000 signature bond through pretrial level 3. The stay away, the no contact, and no drugs, alcohol, weapons while out on bond.
Understood. Thank you, Your Honor.
All right, good luck to you, Mr. McKinnis.
Your Honor, I do have a quick question for you. He does have a Florida hold from 2017. So when is he to report after he gets back from his hold? I just want to make sure.
He's to report as soon as he gets out of custody, whether if there's the hold in place and he's transferred, then he's to report after that. If he gets out on the violation of probation and they release him, then he's to report after that. So as soon as he gets out of custody, he's to report to pretrial.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
Next, Judge, I have position number 33 and 34, Sonia Stevens.
And this is also a negotiated plea, Mr. Dodd.
Yes, Judge.
Good morning, Ms. Stevens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you got to scooch up for me. Okay, thank you. You can place your hand down, ma'am. Yes, Ms. Harrison.
Yes, Your Honor. For count 1, afraid, the state's recommendation is time served. 38 days, credit for time served, 19 days. The defendant was incarcerated from October 17th to the 22nd of 2024, and then subsequently on June 19th. For the public drunk charge, count 2, the state's recommendation is time served, 38 days, credit for time served, 19 days. And with the same incarceration dates. And for position 34, the charges will be null prost upon plea to underlying offenses. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea.
Judge, we so stipulate and ask the court to follow the state's recommendation. And Judge, I neglected to mention this earlier. For clarification purposes, on position 35, which is the FDA, she was actually incarcerated in Clayton County. That incarceration has been uploaded into Odyssey. So I was going to submit, I mean, I know the case is being non-pros, but I'm going to submit an order to technically set aside that bench warrant because she's really was not in bench warrant status since she was incarcerated in Clayton County. That doesn't affect or change the plea. We're asking the court to follow the state's recommendation.
Okay. So if you'll get that information to Ms. Harrison, she'll take a look at it, and then whatever you all get to me, I'll get it signed.
Thank you. And I apologize, Ms. Harrison. I completely forgot to do it last night. So
It's no problem. Thank you.
thank you, Judge.
Okay. Okay, if nothing further, Ms. Stevens, it's my understanding that in case 24 CR 007122A, you wish to plead guilty to a fray in public drunk. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, ma'am.
Thank you, Judge.
Go to position 28, Mr. Seaborn.
Negotiated plea, is that correct?
That is correct, Your Honor.
Good morning, Mr. Seaborn. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor, the state's recommendation is a 12-month probation, served 30 days, credit for time served 11 days. The defendant has been incarcerated since June 21st. Balance probated, 40 hours of community service, a stay away from BP gas station located at 245 Memorial Drive. And we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea.
And defense so stipulates for the purpose of the plea, we just ask that the court follow the state's recommendation.
Mr. Seaborn, it's my understanding that in case 25 CR 003467G, you wish to plead guilty to criminal trespass. Is that correct? Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up that right? Say it again for me.
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Seaborn. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay? All right, good luck to you, Mr. Seaborn.
Go to position 26, Mr. Reginald.
What is the announcement, Mr. Reginald?
That is going to be a negotiated plea, Your Honor.
Good morning, Mr. Reginald. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Thank you. Ms. Harrison?
Yes, Your Honor, for count 1, criminal trespass and damage to property, the state's recommendation is 12 months served, 28 days, credit for time served, 14 days with the balance probated. The defendant has been incarcerated since June 18th. Completion of an AA class, no contact with Angela Ellison. We're also asking for a restitution to be determined within 30 days. For count two, I'm sorry, Your Honor, we'll take that off. No restitution. For count two, Your Honor, it'll be 12 months, served 28 days, credit for time served 14 days, balance probated with completion of an anti-theft course, 40 hours of community service, and again, no contact with the victim, Ms. Angela Ellison. And count three is 12 months probation concurrent with count one. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, Your Honor.
How many AA classes is he agreeing to go to?
It'll be up to the court's discretion, Your Honor, with the AA classes, but we're asking that he complete an AA class and an anti-theft course.
Where is that? Oh, okay.
Okay, well. Mr. Masajian?
Defense so stipulates for the purposes of the plea this morning, we just ask that the court follow the state's recommendation. And that we do receive some guidance on what the court would seek for Mr. Reginald if he does have to attend the AA classes as part of the plea deal.
We could do 5 days of anger awareness, Your Honor.
Okay.
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 So you're agreeable to 5 days of anger awareness?
Yeah.
Yes, Judge.
Okay. Mr. Reginald, it's my understanding that in case 25 CR 003392H, you wish to plead guilty to criminal trespass and damage to property, theft by taking, and criminal trespass. Is that right?
Yeah.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Yeah.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Reginald, when you complete the terms of the probation, I'll have it terminate. So the sooner you get it done, the sooner you won't be on probation, okay?
Okay.
All right. Good luck to you, sir.
All right, man.
Petition number 3, Bailey.
Also a negotiated plea, Mr. Dodd?
It is, Judge.
Okay, good morning, Ms. Bailey. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
You gotta talk loud. Yes, sir.
Okay, thank you. You can place your hand down, ma'am. Ms. Harrison?
Yes, Your Honor, the state's recommendation, count one is 12 months probation served, 54 days with credit for time served, 27 days. The defendant has been incarcerated since June 5th. The balance will be probated. We'd ask for completion of a BHET, 40 hours of community service, a stay away from 590 Main Street, and no further violent contact with Rizikui Adisa. And for count two, criminal trespass, 12 months probation concurrent with count one. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. And that'll be all for the state, Your Honor.
Your Honor, we stipulate for purposes of the plea, I would ask the court to consider either waiving the first 2 months of probation fees or on the back end to place on non-reporting upon completion of all the conditions, Judge.
Okay. Ms. Bailey, it's my understanding that in case 25 CR 003184A, you wish to plead guilty to loitering and prowling and criminal trespass. Is that right? Okay, you're gonna have to scooch up for me, mate. Okay, I'm sorry, I still can't hear her, Francois. Say it again for me. Francois, we can't hear her for some reason.
Just talk really, really loud. Use the outside voice. Yes, sir.
Okay, thank you. Are you under the influence of any drugs or alcohol at the present time? You've been represented by Mr. Haddad. Are you satisfied with what he's done for you? Say it again. Is that a yes?
Really loud. The speakers right here. Yes, sir.
Okay, you understand that you have a right to a trial by jury on this charge, and that by pleading guilty, you're giving up that right?
Yes, sir.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Bailey. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, ma'am.
Thank you, Judge.
You're welcome.
Judge, we can go back to, Mr. Coffey, positions 8 through 10.
Judge, Mr. Coffey has now decided just to accept the state's offer.
Thank you.
Okay.
God bless your heart, young. Thank you very much.
Okay. We have pretty extensively gone through this, Ms. Harrison. If you want to go ahead and put on the record for the state, and I believe, let me just start at the top. Mr. Coffey, if you can raise your right hand for me, please, sir. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Harrison, the state recommendation on each charge.
Okay. For count one, position 8, which is the theft by shoplifting, the state's recommendation is 12 months probation, served 90 days, credit for time served 26 days. Balance will be probated, completion of an anti-theft course, 40 hours of community service, a $500 fine, a stay away from the BP gas station located at 464 Windsor Street, Southwest Atlanta. For count 2, which is willful obstruction, 12 months probation concurrent with count 1, and also a $300 fine. This is a global recommendation. Position 9, count 1, criminal trespass and damage to property. State's recommendation is 12 months probation, served 90 days, credit for time served 28 days. Balance served, a stay away from 884 Rose Circle Southwest, which is also a global recommendation with position 10, which is a theft by shoplifting. State's recommendation there is 12 months probation, 90 days, credit for time served 90 days, credit for time served 26 days, concurrent with 24 CR 007458, which is position 8. The balance will be probated, a stay away from Chevron located at 507 Joseph E. Lowry Boulevard, Southwest. We ask that the defendant stipulates venue ID and facts of the case for purposes of the plea, Your Honor.
And before he does, Mr. White, if you'll just indulge the court, I understand that he has some open charges, that there are, I'm not sure whether or not we've had the opportunity to speak with anyone who's representing him regarding those charges, how this may or may not affect those pending charges, given that this is not a time served plea. I'm not sure whether or not the court would be happy to give you that opportunity, but I just want to make sure that he understands that that this could affect those other charges as he goes forward. So,
Judge, we did discuss it. The felony pre-indicted case, it's similar, but not that. Hold on. We don't think that it would affect those cases at that point, given other issues, record, so on and so forth. So he has decided, with that discussion in mind, that he wants to go ahead and go forward. So we do stipulate for the purposes of the plea, and just ask that his probation potentially go non-reporting. He does have quite a bit to do on probation, and if he gets all of that done, I think non-reporting would be appropriate.
Okay. If nothing further, Mr. Coffey, it's my understanding that in case 24CR007458F, you wish to plead guilty to theft by shoplifting and willful obstruction of law enforcement officers. In case 25CR002800F, you wish to plead guilty to criminal trespass and damage to property. And in case 25CR003216F, you wish to plead guilty to theft by shoplifting. Is that correct? Say it again for me.
Yes, Your Honor, yes. Yes.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right?
Sure, Your Honor.
Has anyone forced you or coerced you to plead guilty?
Yes, sir.
And that was a no?
No, sir. Yes, I said no.
Okay, I'll accept the plea as negotiated, Mr. Coffey. Once you complete the terms of the probation, I'll have it go to a non-reporting status, okay? Good luck to you, sir.
Thanks,
So
Your Honor.
hard. Enjoy the rest of your day, Your Honor. Thank you.
You as well, sir.
Next is position 11, Mr. Cresswell.
What's the announcement on Mr. Cresswell?
This will be a negotiated plea.
Good morning, Mr. Cresswell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. The state's recommendation is 12 months probation, served 22 days, credit for time served 11 days. The defendant has been incarcerated since June 21st. The balance will be probated, a stay away, 40 hours of community service, a stay away from BP gas station located at 245 Memorial Drive, Southeast. And the state is not opposed to the defendant going non-reporting after completion of community service.
Hey,
And we
could
ask that the defendant stipulate, to venue ID and facts of the case.
no worries. Could you repeat, just the time portion?
Yes. The time is 12 months probation, served 22 days, credit for time served 11 days.
Okay. Broke out. Judge, we do stipulate for the purpose of the plea and just ask you accept the plea as negotiated. And as such, the probation go non-reporting.
Okay, Mr. Cresswell, it's my understanding that in case 25CR003466Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yeah.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Cresswell. When you complete the terms, it'll go to a non-reporting status. Good luck to you, sir.
Thank you, Your Honor.
Welcome.
You can go to position 14, Mr. Dove.
What's the announcement?
It's going to be a negotiated plea as well, Judge.
Okay. Good morning, Mr. Dove. I'm Judge.
How you doing?
I'm doing well, Mr. Dove. Good morning. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. The state's recommendation for count of theft by shoplifting is 12 months probation, 38 days, credit for time served 38 days, credit for time served 19 days. The defendant has been incarcerated since June 13th. The balance will be probated, 40 hours of community service, an anti-theft course, and a stay away from all Home Depot stores. We ask that the defendant stipulate to venue ID and facts of the case for purposes of the plea. That'll be all for the state, Your Honor.
Your Honor, we do stipulate for the purpose of the plea, accept the plea as negotiated and this asset is probation terminated upon completion of his requirements.
Mr. Dove, it's my understanding that in case 25 CR 003330G, you wish to plead guilty to theft by shoplifting, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Dove. When you complete the terms, I'll have the probation terminate. So the sooner you get it done, the sooner you won't be on probation. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
You're welcome.
Next is position 19, Mr. Hendrick.
Your Honor, this is going to be a non-negotiated plea.
Jail time is what's not negotiated.
Yes, Your Honor.
Good morning, Mr. Hendricks. I'm Judge Eric Morrow. This is the state all-purpose calendar. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can place your hand down. Thank you, sir. Ms. Washington, may I get Mr. Hendricks's history, please?
Yes, Your Honor. Please just hold one moment.
And while you're doing that, Ms. Lewis, are you with me?
Yes, sir, I am.
On positions number 7 and number 17, I have conflict down. Do we have a conflict attorney that's, and I'm not sure whose cases those are. I haven't seen Ms. McLeod come on with us this morning, so I'm not sure if they're her cases or not. Will you check on that for me?
Can you give me the names of the last name? Because I think the count is kind of off on me.
Okay, I believe Calvin Butts and Nicholas Gonzalez Ramirez.
Okay.
Thank you. Yes, Ms. Washington, whenever you're ready.
Yes, 11 arrest cycles. The last arrest appeared to be from April of this year out of Cobb County for simple battery. There was also an arrest in August of last year for willful obstruction out of Clayton County. No disposition was listed. In 2024, there was convictions out of Spalding County, including 2 counts of theft by shoplifting, simple battery, and 3 counts of willful obstruction. There is also a probation violation in 2023 and 2022, an FTA from 2022. In 2022, there was a misdemeanor conviction for driving without a valid license. In 2019, there was first offender treatment for a burglary in the 2nd degree out of Paulding County. That was sealed in 2024. There was a 2022 felony conviction for theft by taking out of Paulding County. A 2022 theft by shoplifting and furnishing a person below the legal age out of Spalding County, and nothing further, Your Honor.
Yes, Ms. Harrison.
Yes, Your Honor. On June 16th, officers were dispatched to Rickshaw Thai Street Food in reference to a disturbance. When they arrived, they spoke with the victim, in this case, Ms. Laura Rivera. She's an employee at the restaurant, and she informed officers that a male had come into the restaurant asking to use the phone because his car broke down. She offered the restaurant phone to him, and he began acting aggressively and asked to use her personal cell phone. He lay down at the counter bar, and she stepped out from behind the bar to go deal with other customers. And as she did that, the defendant stepped from in front of the bar to behind the bar, and she observed him grab a bottle of Casamigos Añejo tequila. She attempted to stop him from taking the bottle, but he stood in front of her in an intimidating manner. So she allowed him to leave as she was scared. She described him to officers as wearing a green shirt with a face on it, and having green shirt and having face tattoos. And officers recognized that on the drive into the dispute location, they'd actually seen the defendant matching the description that Ms. Rivera gave. They went outside and approached the defendant up the road, and asked him if he had gone into the restaurant, and he stated he did not steal anything. He was not at the restaurant. They went back to the restaurant and viewed security footage and actually confirmed that it was him, and went to place him into custody, and he was uncooperative and refused to give his hands to officers. But they were able to locate the bottle of Casamigos tequila in the waistband of his jeans during a search incident to arrest. Yes, Your Honor. And yeah. And the state's recommendation here, would you like the recommendation?
Yes, please.
Okay. Count one was 12 months probation, served 60 days, credit for time served 15 days. The defendant has been incarcerated since June 16th. The balance will be probated, a stay away from Rickshaw's High Street Seafood. It's located at 1495 Alpharetta Highway, completion of an anti-theft course, and 40 hours of community service. For the willful obstruction of law enforcement officers, state's recommendation is 12 months probation with credit concurrent with count one and a $300 fine. For the simple assault charge, the state's recommendation is 12 months probation concurrent with count one and no further contact with Laura Rivera, and also an 8-week anger management course. That'll be all for the state, Your Honor.
Mr. White?
Yes, Your Honor. We're just asking that all of the requirements from the probation recommendation stay in place, and asking to be given credit for time served. In addition, he's willing to add the condition to probation that he checks himself into rehab. And there is a rehab at Serenity Grove in Athens or North Atlanta Behavioral Health that he knows that he can get into. And we would make that a condition within the first 30 days of release in exchange for time served.
What is the name of the rehab facility?
Serenity Grove. The first one he mentioned is called Serenity Grove. It's in Athens. And this would be a residential rehab center. So once he's in, we would just ask that while he is in rehab, he would be allowed to report by phone to probation. It will be at least a 30-day program.
What does the state think of that?
The state does like the proposition. I think we'd be agreeable to that, Your Honor.
Okay. I'd also have him be on probation for the entire 12 months, reporting probation for the entire 12 months. It would be 12 months to serve, 30 days, credit for time served, 15 days. All the other conditions, along with that he is to report to inpatient rehab at Serenity Grove within how long within getting out of custody?
We'd ask for 30 days, Judge, so to make sure that he can organize getting in, family, all of that.
And within 30 days of getting out of custody. Would the state be agreeable to that?
The state is agreeable to that, Your Honor.
Okay, so this becomes a negotiated plea. Very good. Anything further from anyone?
No,
Okay.
from the defense.
Yes,
Right.
Ms. Young.
It's you're gonna allow phone reporting?
Yes, I'll allow phone reporting while he is while he is in rehab.
Thank you.
Okay, thank you. Mr. Hendrick, it's my understanding that in case 25 CR 003366F, you wish to plead guilty to theft by taking, willful obstruction of law enforcement officers, and simple assault. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation? You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up that right? Has anyone forced or coerced you to plead guilty? Say it again for me.
No.
And I'll accept the plea as negotiated. I will also require that you be on reporting probation for the entire 12 months, sir. Good luck to you.
Thank you. Thank you, Ron.
You're welcome.
Thank you.
Oh, you're talking. Actually, you can take this, yeah, okay, then we'll do that. Your position 25, Bernard Mitchell, that'll be a negotiated plea.
Okay. Good morning, Mr. Mitchell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. For the charge of simple battery, family violence, the state's recommendation is time served, 302 days, credit for time served, 151 days. The defendant has been incarcerated since October 17th of 2024. We ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea. And that'll be all for the state, Your Honor.
And defense so stipulates for the purposes of the plea this morning, we ask that the court follow the state's recommendation for Mr. Mitchell.
Mr. Mitchell, it's my understanding that in case 25 CR 003403D, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation?
Yes, ma'am.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up that right?
Yes, ma'am.
Has anyone forced you or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Mitchell. Good luck to you, sir.
Next opposition is 30 and 31, Mr. Smith.
And Your Honor, this is a negotiated plea. I believe I had initially announced that it would be a waiver of arraignment and an announcement of guilty, but Mr. Smith has decided to accept the state's offer this.
Okay. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, indeed, sir.
Okay. You can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. The state's recommendation for battery family violence is 12 months served 38 days, credit for time served 19 days. The defendant was incarcerated on August 28th through August 30th of 2024 and subsequently on June 16th. The balance will be probated, completion of FVIP, 40 hours of community service, no contact with Danielle Robinson, and stay away from the incident location, and no firearms. And for the FTA, it'll be null prost upon the plea of the underlying charge. And the state asks that the defendant stipulates to venue, ID, and facts of the case for purposes of the plea. And that'll be all for the state, Your Honor.
And defense so stipulates, we would ask that Your Honor follow the state's recommendation this morning.
Okay. Mr. Smith, it's my understanding that in case 24 CR 006105B, you wish to plead guilty to battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Yes, indeed.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, indeed.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Smith. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Next is position 37, Mr. Thomas.
And Your Honor, this should be a negotiated plea.
Okay. Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Ms. Harrison?
Yes, Your Honor. In the charge of criminal trespass, the state's recommendation is 12 months, served 60 days, credit for time served 17 days. The defendant has been incarcerated since June 16th. The balance suspended, Stay away from 3252 Verdant Drive. No further violent contact with Derek Cook. The defendant also does have another case. It's 23CR001206F. The state's recommendation in that case is 12 months, serve 18 days, credit for time served 9 days. Balance probated and no further violent contact with Derek Cook. Completion of FVIP and no firearms. And we ask that the defendant stipulate to venue, ID, and facts of the case for purposes of the plea, Your Honor. That'll be all for the state.
What is the charge for the add-on?
It is a simple battery family violence.
Yes, Mr. Massajuddin.
Thank you, Your Honor. Defense so stipulates, for the purposes of the plea this morning, Mr. Thomas would ask that Your Honor follow the state's recommendation.
Mr. Thomas, it's my understanding that in case 25 CR 003346F, you wish to plead guilty to criminal trespass. And in case 23 CR 001206F, you wish to plead guilty to simple battery family violence. Is that correct? Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up that right?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Thomas. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, sir.
Next is position 23, Mr. Knox.
And this is going to be a bond hearing.
That's correct, Judge.
What was the previous bond?
Your Honor, there was not a previous bond set.
Okay, so I have the add-on calendar of 24 CR 005942C with the
24.
dogs at large, and then I have the failure to appear.
What was the case number you have for the dogs at large? 2400.
24 CR 005942C.
That's the underlying case. That's correct, Your Honor.
Okay, and so what was the bond for the underlying case?
So it was in another court. From what I saw, it looks like they issued a citation, and he didn't make it to the hearing, and that's how FTA was issued, but I wasn't able to access any actual bonds.
Where did he fail to appear?
Give me just 1 second. Let me pull that back up since the computer.
Your Honor, if I could offer some assistance, this was an environmental court case.
Thank
In magistrate court, the defendant failed to appear on his dog at large case, and then it was bound over by the court and an FTA was issued. It was bound over to state court and an FTA issued at that point. The defendant, because he has an FTA, that's why he doesn't have a bond, not because a bond was, because it was a citation. Once he had an FTA, that's what connected to him.
Okay. And I'm sorry, the FTA was in magistrate court?
Yes, Your Honor. It was bound over from the magistrate court in environmental court, and they also
Okay.
issued an FTA
Okay.
as part of the bind over. I will say that the bind over happened, it looks like, because the case is now in front of Judge Dixon. Oh, actually, Your Honor, I take that back. He actually FTA'd at plea and arraignment in Judge Dixon on March 14th of 2025. So it was bound over as a citation from magistrate court to state court. He then went to plea and arraignment on March 14th, and that's when he bench warranted. So although he doesn't have, I'm not sure if they attached a bond to him on that FTA. But we would ask that it just go back to Judge Dixon, since that was a very recent plea and arraignment hearing that he missed.
And why did he miss, thank you. Why did he miss that date? Mr. White? Y'all are on mute there.
But my understanding is that he missed the address because it went to the, missed the court date because it went to the wrong address. I think it actually may have gone to the address of the person that should actually be in court for this case as well. I mean, we have several factual issues. I don't have any discovery. There's no discovery in the system on this case. We're asking him to be allowed to sign his own bond. He's been in jail now 11 days. He says that these dogs were not his, they were his nephew's. He's the one that actually called animal control. His nephew lives in a home across the street. The fact that there's no bond, he's been in jail 11 days with no bond, no ability to bond out. We have no discovery on the case. His side of the story is completely different from what I assume the state's would be. We'd ask him to be allowed to sign his own bond in the dog at large case and come back to Judge Dixon.
I want to make sure that his proper address is in the system and make sure that it wasn't. So can you put the proper address? Can we make sure that the clerk has the proper address?
Sure.
And Your Honor, if I may briefly respond, this is Danny Knox, correct?
Yes.
Just want to make sure we're on the same page. He actually does have a $8,000 surety bond on the FTA. So I'm not sure where the no bond argument is coming from. I just looked him up in the jail system. He's got an $8,000 surety bond. Additionally, he did not have an attorney at the time of plea and arraignment, which is why he didn't receive discovery. If PD White, just like PD Haddad has done in the past, had reached out to me and asked me to send him discovery, I would have, but I didn't receive any message asking for discovery on this case, so I didn't know they didn't have it. I will say there wasn't an attorney at the time he failed to appear for plea and arraignment, which is why he didn't receive it before plea and arraignment.
I'm going to let you all work that out down the road. I just want to make sure that if what I'm being told is accurate, I don't want him sitting there because he didn't get notice. So, again, if we can make sure that I have his proper address.
But we can give that to you over the Zoom if you'd like. He's really established.
Okay, so if we can make sure put that in the chat for me. And I want to make sure that Ms. Falk, are you able to get me what address the notice went to?
It went to 979 Callahan Street, Atlanta, Georgia, 30318.
And that's our information that what we thought probably happened. It should have gone to 976.
Okay, and either Ms. Young or Ms. Lewis, can you tell me what address we have in the on file for him?
976 Callahan Street under the 24 CR case.
Okay, so it did go to the wrong address. All right.
We have 976. If I'm not mistaken, 976 is the correct address. It was just mailed to the wrong address.
Okay, so he didn't get proper notice. All right, so because of that, I am going to give him a $500 signature bond through the jail on each charge. Makes for a total of a $2,500 signature bond through the jail. And as far as the failure to appear, is there going to be any objection, given that he did not get proper notice, Ms. Falk, of withdrawing that?
No objection, Your Honor.
Okay. All right. So, Mr. Knox, you're gonna have to make, now that we have everything properly for you, I'm gonna give you the opportunity to make that plea and arraignment calendar the next time. So make sure that you, once you get notice of that next hearing date, that you go, that you make sure that you go to that. And Mr. White, if he qualifies, let's make sure that he has someone representing him from your office at that calendar, okay? Ms. Lewis?
Yeah, I'm updating his address. I just want to make it clear that it is 979.
No, ma'am.
976.
976,
Ma'am, cat in hand.
Everything else is correct.
976. Okay, I just want to make sure the address number is correct. 976. Okay.
Okay. All right, you have everything you need, Mr. White?
Yes, Your Honor. Thank you.
All right, very good. Good luck to you, Mr. Knox. Okay, and positions number 7 and 17, those are Ms. McLeod's cases. She had requested that they be reset to the July 10th SAP calendar. So position 7 and 9 will be reset till July 10th.
There's also, Mr. Butt has another outstanding case, but it's not linked on his booking screen with the case. He has 2 cases, so instead of 1. So make sure that one is added on to the calendar.
Okay, thank you. And position 16, have I signed the transfer order? Or has that been presented to
So,
the
Your
court?
Honor, we have to represent the transfer order to you. It was transferred, and then the DA's office transferred it back in error. I had to reach out to them, and they are agreeing that it is in fact their case. And so I have to send you another transfer order on that case.
Okay, so once I get that, I'll get that signed.
Yes, Your Honor.
Do we have anyone else on the 9 o'clock calendar that we did not take care of?
No, Judge. I don't believe so.
Okay, and I'm not sure that the other calendar with David Ellerby on it, I'm not sure what type of calendar that is because there was.
Your Honor, I did reach out to the clerk's office. They told me it was a domestic violence bench warrant calendar. I wasn't very clear on what kind of calendar it was either, and so I did reach out. They cleared that up for me. So it is a domestic bench warrant calendar. I will say we didn't make a recommendation because I didn't know that it was a domestic violence bench warrant calendar. So I do apologize for that. But if Your Honor can just address the bench warrant, and if whatever Your Honor decides, maybe we can come up with a recommendation if necessary.
Okay, well, let's see, it's a little before, and I take it that this is an 11 Well, it says a 9 o'clock calendar on my calendar, so I'm not sure if it was supposed to be a
It's
11
supposed to be
o'clock
11
calendar.
o'clock calendar, Judge. It's supposed to be 11 o'clock.
Okay, all right. So it's not quite 11 o'clock yet. Is David Ellerby with me? Okay, he doesn't seem to be with us as of yet. I will give him until 11 o'clock to join the call. Let's see. Ms. Young.
Yes, sir.
Okay, so let me see is there someone that's on this iPhone 4 that has business with the court?
I'm asking him to unmute. I know Mr. Ellaby's mother called this morning. I'm asking her, ma'am, click the button. There you go.
Hello,
Yes, ma'am. Which case are you here for today?
the bench warrant.
Okay,
The
and with David Ellerby?
No,
No, okay. What's your name?
Shakira Key.
Shakira Key?
Mhm.
And okay, I don't have your case on. Do you have a case, Miss Key?
Yes, at 11 o'clock.
Okay,
You
I
have a
don't
case
have you
number?
on my, Miss Lewis?
I was asking, does she have a case number? Do you have a paper that you came to the
Yes.
clerk's office? What's the case number on that, please, ma'am? It should begin like 22 or 24 CR, 23 or something. CR number.
It's 25 CR.
Okay, and what's the rest?
R 001953C.
Wait a minute, say it slow. 0019.
11953C.
Who came in, Judge, to get her case reset. Apparently, whoever reset the case in the clerk's office gave her this date, and they didn't put it on the counter. They do have her scheduled for today, date. I can put her information into the system or give it to the solicitors and if they want to deal with it and bring it up. It's the case that she failed to appear in front of Judge Meyer Dixon. It's a simple battery, family violence, criminal trespass case. So the number that
Okay.
she correct.
Miss
Did you
Lewis,
get
I can address that one.
Okay. Do you want me to give y'all in the chat? I'll put the information in the chat.
I have the information. I pulled it
You do?
up.
Okay, but I need to give it to the judge. So
Oh, sorry.
that's okay.
Okay, and Mr. Haddad, can we get someone to speak with Miss Key?
Yeah, yeah, we can, Judge.
Judge yes, I'll speak with her.
Okay, and Ms. Falk, would you send Mr. White the recommendation? I know
can
that.
formulate one quickly, Your Honor.
Okay, thank you. All right, I'll give you the opportunity to do that. Ms. Keith, Mr. White, can you go ahead or can someone give Ms. Keith the number to call so that when you get the recommendation, you can talk to her?
Ms. Keith, do you have something to write with?
Yes.
404
Okay.
612 2060.
Okay, I got it.
Call me right now.
Okay.
Okay, so we'll be in recess for a few minutes.
Does the court want to go over the calendar, I guess? Okay. I'll just wait.
That's what we're about to do with all of this.
That's fine with the court.
Yeah, I know, Your Honor. I was printing Ms. Key, plea sheet out just in case she took a plea.
Okay. Whenever you're ready.
Position 1 or 2 in all props, and I did receive those from, Ms. Casey. She gave them to me. You already signed them. Position 3 was the negotiated plea. Position 4 was jail jury. 5, same announcement. 6, reset 711 SAP. Position 7, 710 SAP, and I'll add the other cases in. Position 8, 9, and 10 were negotiated. Position 11, negotiated plea. Position 12, reset further notice released. 13 and 14, negotiated plea. 15, jail jury. 16, reset 7-8 SAP. 17, reset 710 SAP. 18, jail jury. 19, plea. 20, jail jury. 21, jail jury, and 22, jail jury. 23, the failure to appear is going to be non-pros or withdrawn. The bond for the additional case was $2,500 SOB. Was that through the jail, Your Honor?
Tell me again, what position?
Mr. Knox, the dog at large cases.
Yes, it was through the jail.
Okay, $2,500 SOB jail. 24 was a 5,000 good bond. I'm sorry, a 5,000 SOB pretrial level 3. No further contact and stay away. 25 was a plea. 26 plea. 27 plea. 28 plea. 29 is jail jury. I'm sorry, it's reset to the comp calendar for 7/17. 30, it was a plea. 31, non-pros. 32 was a plea. 33, plea. 34, non-pros. 35 and 36 was released, reset further notice. 37 was a plea. 38 was non-pros. And it also was a plea with the added additional case. And 39 was released, reset further notice. 40 was released, reset further notice. And 41 was the plea. That completes the call of the calendar, Your Honor.
Okay, any questions or concerns? Okay, if not, is this Mr. Ellerby that I have on the line with me?
Yes, it is.
Okay, good morning, Mr. Ellerby. Let's see, Ms. Falk, have you had the opportunity to come up with a recommendation for Mr. Ellerby?
Your Honor, I just sent the recommendation for Key. I can come up with a recommendation for Mr. Ellerby as well.
Okay, if you'll go, thank you. If you'll go ahead and do that for me. Mr. Ellerby, I'm going to have you speak with the public defender this morning. Mr. White, are you going to represent Mr. Ellerby as well?
Yes, Judge.
Okay.
We're ready.
So if Mr. Ellerby, if you'll can get something to take down, a number to call Mr. White with.
Give me 1 second.
Okay.
I'm ready.
All right, 404-612-2060. And, give me just a minute because we're ready on this key. If you want to do that, or
Okay.
And PD White, I was just going to tell your team that the recommendation for Miss Key is in the courtroom 2 chat.
Okay. This is her first time missing court, so we'll be taking plea offers at this point.
Yeah, I believe Ms. Falk is preparing a recommendation for Mr. Ellaby here, so I'm going to give her that opportunity. So we'll get with Ms. Key as soon as Ms. Falk is available for us.
Thank you, Your Honor.
Judge Morrow?
Yes, Mr. Dodd.
Judge, there's some confusion. You know, as you know, we're switching SEA from 6 days a week to 4 days a week. We were told it's effective July 1st. The sheriff's office was told on the 7th.
Right. No, it's not. It's my understanding that it's not effective until next week.
Well,
That is correct.
That's
PD Haddad, we
unfortunate.
received notice. It was effective July 7th. I apologize for the confusion.
The problem is I don't have any of the lawyers for today. Because we were told, I mean, I'll try and reach out to Mike. I mean, we haven't done any conflict checks. We haven't done anything. Because we were told from Mr. Talley that it's effective July 1st. So,
Okay, I have down that we still haven't the SEA calendars for today and also for Thursday.
yeah. Well, I mean, Thursday is not a problem. We'll address Thursday, but today is going to be a problem. So I'm just letting the court know. I'll have to
Okay.
in the office. I'll do everything I can, but it's going to be a long day.
How many cases do we have on that calendar this afternoon?
20 right now. It may be lower. It's 20 people on the pool sheet.
I'm working on that myself here. Doing a little bit of double duty today.
Okay.
There are only 13 that will go forward. I sent an email to Mr. McLean and Miss Tyshawn Tucker, letting them know. I apologize, PD Haddad, I didn't know they weren't there. Letting them know that there was a list of cases that either are pending felony review or have been NOD'd or bonded out. So that actually took our list quite a bit down from 20 to about 12 to 13 cases. And I'm finishing up while I'm doing this. I'm also finishing up accusing those cases.
So Ms. Falk, do you mind sending that to me as well?
Yes, no
Judge,
problem.
I'm
I
gonna
will
head
forward
back
that
to
right
the office.
now.
I'm going to head back to the office now.
Okay.
Thank you, Mr. Dunn.
Yeah. I'll try to reach Mike.
So, Judge, do you want me to speak with Mr. Ellaby before we handle Ms. Key?
Why don't we do that and give Ms. Falk the opportunity to get that recommendation together? So, Mr. Ellaby, go ahead and call that number and speak with Mr. White there, and Ms. Key will be with you as soon as we can.
Okay, and to confirm, that phone number was 404-642-2060?
Yes.
Thank you.
We'll be in recess until Mr. White's available. Sergeant, how are you today?
Good to see you. How you doing?
I'm doing well.
So are we gonna have Mr. Bean or not? Okay. Yeah, they told me on the 7th, and at the 7th.
Your Honor, just a brief announcement, so courtroom 2 is aware.
Yes.
The state will not be making a recommendation on Mr. Ellaby's case. He actually has another case involving the exact same victim that's under 24 PI 008176 that occurred on November 4th of 2024 after our case. And it looks like the case was opened in the DA's office June 2nd of this year. So based on the fact that we have a subsequent case with allegations of abuse against the same victim, Monica Newton, the state just declines to make an offer in the misdemeanor case at this time until we've had a further conversation with the DA's office regarding the felony.
And Ms. Ellaby, still waiting on a call. I'm sitting next to the phone. You can hear me.
And PD White, can you tell PD Haddad that I just sent him the
Left.
updates on the case filings?
He left.
Oh, okay.
Yeah, he's headed over to the office. So
Understood. So he should get those when he gets over there. Thank you.
Judge, I don't see Ellaby on the Zoom anymore, and he has not called here.
Okay, well, presumably he had to get off to make that call, but let's not hold up court. Let's go ahead on and deal with Ms. Key's case here. Ms. Key, are you with me?
Yes.
All right, come on camera for me. Okay. Good morning again, Ms. Key. I'm Judge Eric Morrow. This is the DV bench warrant calendar. Let's see, I take it that Ms. Key missed a court date. And could you also tell me, Ms. Falk, what she's charged with, please?
Your Honor, Ms. Key is charged with simple battery, family violence and criminal trespass. It looks like the bond was ordered forfeited on May 27th of 2025. Let me see exactly what that court date was. Plea and arraignment on May 16th of 2025 before Judge Dixon is when the FTA occurred. The bond was ordered forfeited on the 27th, and then the reset date was issued on June 16th.
Okay. Mr. White?
Yes, Judge. Ms. Key was living in a place where in a hotel and could not receive mail there. She is no longer there. She has changed her address with the court, and this is the first time that she's missed court. So we're just asking if the bench warrant be set aside.
And Ms. Key has a stable place to stay at the present time?
She does now, Judge.
Okay. Ms.
And Your Honor,
Key, go ahead, Ms. Falk.
The state doesn't object to a reset on this, a lift of the bench warrant and a reset. This is her second arrest. She has no previous FTAs.
Okay, thank you. So, Ms. Key, this will be set aside. This warrant will be set aside on this occasion. It's up to you to make sure that if you move or that you make the court aware immediately of when you move, and that you keep in touch with the court to make sure that you don't miss any additional court dates. Okay, so I'm going to lift the bench warrant on this case. If it happens again, the bench warrant won't be lifted. Okay.
Okay.
All right. Good luck to you, Ms. Key.
Thank you.
You're welcome.
Judge, can someone send me, we didn't receive any kind of calendar for this, so when I do the paperwork, I'm gonna need case numbers and such, if I can get that emailed.
Okay, Ms. Key was not on the calendar this morning at all. So I take it that Ms. Young, can we generate a calendar for Mr. White?
Yes, we got it. We just revised it. We'll send it over, Mr. White.
Thank you.
Okay. So Mr. Ellaby, we're waiting for you to call.
You're on mute.
So I just called the number and that's not the right number. 404-642-20.
612-2060.
And I'm sorry, ma'am, who's speaking?
His mother. I'm his mother, so he's schizophrenic, or I'm just here with him to help him.
Okay, just wanted to establish who all was here with him at the moment.
Okay.
Do you have the right number now, ma'am?
Yeah, 612-2060.
Yes.
Okay. We'll be in recess until Mr. White returns. Okay, we ready to proceed? Mr. White,
We are.
Ms. Falk, you with me?
Yes, Your Honor, I'm right here.
Okay, thank you. So I take it that Mr. Ellery missed the court date?
Yes, Your Honor, he did. Let me get out of SCA for a minute and pull up SAP.
Okay.
Mr. Ellaby. Okay. It looks like Mr. Ellaby was before Judge Richardson and failed to appear at plea arraignment on June 4th of 2025. And then they had a DV, then he came to the clerk's office and they gave him a DV reset date on June 24th of 2025.
And he missed that date as well?
No, that's today. So they, when he went to the
Oh,
clerk's
oh.
office, they gave him today's date for court. So no,
Okay.
he hasn't
Today's
missed any
July-
other court other than that first clean arraignment.
Okay, well, you said June 24th, and today's July 1st.
I know, I apologize for the confusion.
Okay. All right, so.
And Your Honor, if I may just add, this is his, well, with this new case, it is his third arrest, and other than, well, he does have an FTA. It looks like an FTA was issued for him on November 4th of 2024. Let me just take a look at something. So it looks like he did have an FTA before this clean arraignment date. Okay. So he was arrested on November 5th of 2024 on an FTA. And just going to the jail documents, it looks like the FTA warrant was issued on this case in the amount of $1,500 for, says failure to appear. It was signed by Judge Lal on September 25th of 2024, and he was arrested on it in November. That was a pretrial services FTA warrant for failing to appear at pretrial. So this is actually not his first FTA on the case. It's his second.
That's his first for court, Judge. The other one was pre-trial.
So he failed to appear for pretrial and then failed to appear for court.
Failed to report. But, Judge, I've spoken with he and his mother. He does have some mental health issues, but he is somehow or another, they missed the date, but his mother has assured me that she will do everything she can to get him to court for future dates. We're asking to set aside the bench warrant. This is the first failure to appear, actual failure to appear issued by the court for not coming to court. So we would ask that bench warrant be set aside.
Okay, and ma'am, would you tell me your name, please?
Monica Newton.
Miss Newton, is Mr. Ellaby, I know that he's your son. Is he living with you now?
Yes, he lives with me. I'm responsible for him. Like, I give him his medicine and everything.
Okay.
And Your Honor, I just want to point out, and I thought Miss Newton, I wasn't sure about Miss Newton's relationship with the defendant, but Miss Newton is the victim on this case and on the felony family violence battery that are currently both pending in state and superior court. And I just want to look at the bond on both of those and the criteria. So I just wanted to also alert the court to that.
So the thing with that was, he was having episodes before we found out what was going on with him, before we got him into Grady and evaluated, before they diagnosed him with schizophrenia. So all of that took place before he was diagnosed and given medicine and everything. He has been okay lately, taking his medicine and everything, doing what he's supposed to be doing. So,
And ma'am, who is Destiny Renee Newton?
that's my daughter. So with that incident, they were here. I wasn't here.
Hold on, Miss Newton. Are there any no further contacts?
Yes, Your Honor, there was a no further violent contact with Miss Monica Newton, a no further contact with Destiny Renee Newton, and he's ordered to stay away from 125 Milton Avenue Southeast, which I believe is where Miss Monica Newton lives.
Right. How was he ordered to stay away when he doesn't have anywhere to go but on the streets?
Your Honor, and Miss Newton, I apologize. I'm just telling you what the bond order is from Superior Court this is state court. I'm just informing the judge of the Superior Court's bond order in which he's currently in violation of.
And the contact order for this case apparently was no further violent contact.
Right, but there's a stay away order from the address of Miss Newton's home where he currently is on the Zoom.
I heard the first 2 times. I understand that.
I understand.
Ms. Newton, does he have an attorney that's representing him in the Superior Court case? That you know of?
No, we haven't been to court like this. The court date that we missed was the first court date that I knew of, which is right here that came in the mail a couple days before. So I haven't spoke to anyone. I don't know anything. I have not heard anything about him not being here or not supposed to be here. But this is the only place he has to go.
Okay, so you're gonna have to go back to, or you're gonna have to go to Superior Court to get that modified. That would be the proper way to do that so that he can properly be there. If they find out that he's there, then they could revoke that bond from Superior Court. This is state court. On the state court bond, Ms. Falk, what are the requirements on that bond?
No further violent contact with Monica Newton, stay on prescribed medications, BHET, that was issued by the court, actually, Your Honor, on August 12th of 2024. Now, when he bench warranted on that case through pretrial services, Judge Law issued a new bond of $1,500. I'm assuming that the new bond had the same criteria. I'm assuming she didn't do any modifications that would have changed any of the existing criteria. She usually doesn't.
Okay. And given that I haven't heard anything, well, we haven't heard anything further from pretrial, I'll take it that he is reporting to pretrial at the present time. I can't do anything about the Superior. Go ahead, Ms. Falk.
Your Honor, he was off that pretrial services bond. They came off the pretrial services
came off the
bond.
bond.
And then
Okay.
Judge Law issued a $1,500 surety bond that he made back in November. So the state would ask that he be put back on pretrial services, and that they actually have wraparound services for MH individuals. And as long as the court says pretrial services wraparound level and then puts the level, they will give the defendant MH wraparound services with a actual MH qualified pretrial services person.
Can you define wraparound?
So they basically recommend the defendant for MH services, try to find placement if necessary. Jared Young kind of laid it all out for me when this came up a couple of days ago. They are required to report in person. They have an MH pretrial services officer. They'll do treatment programs, ensure that the defendant returns to court, kind of just do that kind of monitoring. It's just a little more hands-on because of the MH issues.
And Your Honor, I would object to that. He's already in treatment. All that does is add a level of stress and extra reporting, and that I don't think he's already in a treatment program. He's already got services. He doesn't need any of that. So now he's got to report somewhere physically, however often. And that's just another level of control that, may end up costing him coming back here and not getting to court and so forth.
Okay. Why did he miss that plea and arraignment calendar, Mr. White?
I think they just missed it.
Okay.
They just did not get the date.
And Your Honor, that's why the state recommended pretrial services, because they pretrial services FTA'd him in November, and then he FTA'd again for arraignment. So this is, I understand it's his first FTA where he had to go to court, but it is his second overall FTA on the same case.
Can I speak?
No, ma'am. Second, just give me a moment. Ms. Lewis, can we call Judge Richardson's clerk and find out when their next plea and arraignment calendar will be, and if they can place Mr. Ellery back on that calendar? I want him to be seen as quickly as possible, but I don't have any control over Judge Richardson's calendar or what he will place. Could you make that request?
Yes, I can make that request through Ms. Daniels. Also, just let you know, his bond that he has on his case is a good bond. The bonding company, A Rapid Bonding Company, is the one that posted the bond for him. So it is a good surety. So it's still valid bond.
Okay. I'm gonna send this back to Judge Richardson. I want him placed on Judge Richardson's next available, if Judge Richardson will take him, plea and arraignment calendar. Ms. Newton, I'm gonna give you the opportunity to get him there. So when you get the next hearing date, if you miss that date, he is not, the bench warrant is not gonna be set aside again, and he's gonna be in custody. Because of his situation, I don't want him to have to report to custody. I want to give him another opportunity. So I'm gonna set this bench warrant aside on this occasion, but you have to make sure that he gets to that next court date. Do you understand me?
Yes, I can make sure he gets to the next court date if I'm notified of it. That other FTA that they're saying he had, I had no idea about that. The court date he recently missed, we missed it. But the other
Well-
failure to appear back last year, I had no.
Okay, well, what you did have now, and I appreciate you being forthcoming to the court. You did have notice of it and you did miss it, and you should know that if you miss a court date, that a bench warrant is going to be issued for your son, okay? So I don't want to see him back in custody because he's missing a date. So when you get another court date, make sure that you have him there when he's supposed to be there. Mr. White, can we go ahead and I'm not sure if we see if he qualifies so that we can get him some representation prior to him getting back to Judge Richardson if that has not been done?
Certainly qualifies, Judge. And then there will be an attorney at plea and arraignment, but I will also give them a heads up.
Okay.
About the case.
All right, I appreciate that. So I'm going to give you the opportunity, Ms. Newton. You're going to be getting another court date here, hopefully in the not so distant future. Okay?
Okay, thank you.
You're welcome. You have any other questions for the court at this time?
So will that come in a mail as well?
It'll come the same way you got the previous notice.
Okay. All right, thank
All
you.
right.
Verify her apartment address on there. Can you verify your apartment now?
1210.
Okay. I just want to make sure that it was correct. All
Ms.
right.
Ms. Lewis, are you getting the paperwork?
Huh?
Sending the paperwork to you?
No, you sent it to Miss Young. She's
Ms. Young? Okay.
she's conducting the counter. Yes.
Perfect.
Okay. All right. You're free to go this morning, Ms. Newton. You and Mr. Ellaby. Good luck to you, ma'am.
All right, thank you.
Okay, so I think that concludes our business for this morning. Ms. Falk, I know you're doing double duty. I'll see you in a couple of hours, I guess, hopefully.
Yes, Your Honor. Miss Young or Miss Lewis, are either one of you close to Miss Vaughn? I mean, like proximity wise.
I can walk around and get her.
Can you just tell her I'm on my last 3 and I'm finishing up?
Okay.
Still know what I'm talking about.
All right.
Thank you.
You're welcome.
Bye, guys.
All right, see y'all next Tuesday. Have a happy 4th. Thank you.
Thank you, Judge.
All right, take care. Thanks.
We just close this out?
Yeah.